Hi, and welcome to our last installment in our It's a Great I.D.E.A series. Today, we're going to be talking about procedural safeguards. So, welcome. I'm glad that you stuck with us so far and that you're still here. My name is Sassafras Middleman, and I am a parent trainer here at the Family Network on Disabilities. We are a nonprofit, a 501c3. We actually get our funding from I.D.E.A Part D. We are the state's parent training and information center so that parents can come to us and get the information they need at no cost to them. We are family driven and family centered. What we mean by that is that we were founded by a group of parents who came together seeking resources and information. And out of that, the Family Network on Disabilities was born. And we are still here, parents and family members, helping other parents and family members find their way through the special education path. We are not to act as attorneys, doctors, or mental health professionals. However, we get you the information, the resources, the supports, and it's very vetted, up to date. It's directly from I.D.E.A, the state's legislation, the Florida Department of Education, etc. We make sure that you get the information, you understand it, you can relate it to your child, and that you can take that and run with that and be the best advocate that your kiddo needs. So, moving on to our big topic, the I.D.E.A, the Individuals with Disabilities Education Act, is, of course, our nation's federal special education law. Nothing can supersede it, not the Florida Department of Education, not the Florida Senate, not the individual school districts, and certainly not individual schools. We're going to just briefly review the 6 major tenets of the I.D.E.A because we have finally made it to this last segment of our It's a Great I.D.E.A series. So first, we have our free and appropriate public education, our appropriate evaluation, the individualized education plan, the least restrictive environment, parent participation, and lastly, our topic for today, procedural safeguards. So procedural safeguards are the rights and responsibilities that go along with ESE, or Exceptional Student Education Services. Procedural safeguards are designed to make the ESE process fair for both you and the school and to help ensure that your child receives that free and appropriate public education. Procedural safeguards are, a way to give schools and parents, more importantly, rules to help them work together. The procedural safeguards give parents and schools ways to solve problems and settle disagreements. As we know, they're going to come up. Disagreement is natural, but I.D.E.A thought about this and has procedures in place. So, if you have good reason to think that your child is not receiving a free and appropriate public education, you may want to make use of your rights, including your right to mediation, to file a state complaint, or to go into due process. So there are people who will help you do this. So once a year, that school has to give you that piece of paper at the IEP, and if it's virtual, they can send it to you electronically, but they have to give you the information that you have rights to procedural safeguards. And that has to happen at least once a year. You have to get that piece of paper whenever there's initial referral for identification and evaluation into the ESE program, whenever a change in placement occurs, when as a result of discipline, because there are such special provisions for students who have disabilities that have disciplinary issues. Upon receiving a state complaint or the first request for a due process hearing, or whenever you request a copy. So, what does that mean if you have good reason to believe that your child, is not receiving their free and appropriate public education? What does that mean? Well, there's lots of ways that that could be the case. Well, one, maybe you're just not being heard in the IEP meeting. Maybe it's not a brainstorming session. Maybe nothing you've ever said has ever made it into the IEP or towards a goal, not a recommendation, Maybe it could be that you're looking for something specific, like maybe your private therapist has suggested that they have this particular piece of assistive technology and you're having a hard time getting it. Maybe you have a wonderful IEP, but the teacher isn't following it and has no idea of what's on it and the accommodations or the needs. Maybe you have, set therapy sessions 3 times a week, but the school is telling you they don't have a therapist available to service this need. There's all kinds of ways that your child might not be getting their free and appropriate public education. If you think that something is happening and it doesn't feel right, please give us a call. We are here to, be your soundboard and to give you guidance as to what I.D.E.A has to say about it. We'll be happy to provide you with whatever information is that relates to whatever it is that you're having to go through at that time. So, um, you have rights for both you and your child, and you have the right to, first and foremost, again, FAPE, a free and appropriate public education, a completely fair and free individual evaluation, an individualized education plan, an education in the least restrictive environment. That's going back to that LRE that we were talking about, and a yearly review of students' progress towards the goals. You have your procedural safeguards. You have the right to written notice, prior written notice. You have the right to participate as a parent, and you have the right to give, not give, or withdraw consent. So I know we have talked a lot about the right to prior written notice, but it is crucial in parents' participation. We need to know why, what it is that they're proposing. Is it a change of placement? Is it a change in services? What are we going to this meeting about? It's imperative that we as parents are on the same team, that we know what's happening as we're walking in, so that way we're able to give relevant and thought out input instead of it just being an in the moment, okay, I'm being faced with this information. No, prior written notice allows us to know exactly the purpose, the nature of that meeting, who's going to be there, and what stance, if any, we have on whatever the topic of the meeting happens to be. So, there are times that the school has to give you that prior written notice. So you will get it when the school has agreed to or turned down a request that you have made. The school wants to individually evaluate or reevaluate your child. The school's plans to change your child's services under their IEP or their placement. Or the team has decided that your child is no longer eligible for ESE services. The notice should be easy for you to understand in plain language so that a layperson who does not have a legal or special education background can understand the wording. It has to be in your native language. If you need an interpreter, they have to provide you these services. They have to tell you what the school plans to do, or what they're refusing to take action if the case of you requested something. They have to explain the options they considered. They have to talk about any evaluations, tests, records, reports that they use as a factor in their decision to either initiate this proposal or to refuse your proposal. Say you're the one looking for an evaluation, or you're the one wanting to change their placement, or you're the one wanting to change services. It goes either way. They have to give you that prior written notice. It has to tell you your specific rights and how you can get a copy of your procedural safeguards. And it has to tell you who you can call, again, us, if you do not understand the notices. So, and if you don't, please give us a call. We can help you to understand what the nature of that meeting is. We can talk to you about your child, maybe help you come up with some ideas, accommodations, or help you figure out, how you can highlight what you know about your child and bring that to that meeting. So if you do not agree with what that notice says, there are several steps you can take as a parent. One, immediately contact whoever the person is named in that notice. Next, you can call the ESE administrator in your local school district office. Okay, every school district has a district ESE office. Okay, and the person that goes to your IEP meeting is your staffing specialist, or they might be called a district liaison. That's what they're talking about, is they're the person from the district's ESE office. So you can contact them directly if you have had requests that they denied, or you don't like what they're proposing, or you feel like the services in the IEP are not being followed, et cetera, et cetera, et cetera. You can directly reach out to your local ESE district office. You can ask for a meeting, such as another IEP meeting, in writing. Always do it in writing, because there is a timeline that they have to follow and get back to you and say, yes, we're going to have this meeting, or no, we're not going to have this meeting. And again, you're going to have to get that prior written notice. Okay, no, we're not going to have this meeting because blah, 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 blah. And these were the factors we used, and this is why. Um, you can, you may need to write a letter to explain your point of view. Always do that in writing as well. You can ask for free mediation services at any time. This is one of your procedural safeguards. If you believe that the school has not followed the requirements of the of the I.D.E.A. when they were developing that IEP, you can file a formal state complaint, or you can ask for due process hearing. Okay, these are all rights we have as parents. Of course, we have the right to participate. We will be asked and expected to participate in any meeting that has anything to do with determining your child's eligibility for ESE. In fact, they have to have your explicit consent to do that initial evaluation and placement into ESE services. Whether they're looking to develop or write or review your child's IEP, or make decisions about any of your child's services within that IEP, all the way up to placement. Okay. When you're participating, you want to share information about your child and your child's needs. If you have any supporting documentation from private therapists, this is also a good way that we as parents can bridge those worlds. Because I know, I did that with my daughter. She was seeing private therapists, they had plans of care, they had all of this. I'm the one coordinating between the worlds. Bring those elements in. That's something that we parents can absolutely do. Listen to and think about what other people are saying, using active listening. Don't just listen to get your point across. Really try to understand where they're coming from. Ask questions, especially clarifying questions, and not in a snarky way. But if somebody says something and it seems off to you, you can always ask them to repeat what they said, or to say, wait, let me make sure I understand what you're saying. Are you saying blah, blah, blah? Give people a chance to reiterate or to make sure that they have that clarity. Keep notes about that meeting. Now, if you yourself have disabilities, maybe you have auditory processing issues, maybe you were in a car accident like me and you can't remember things very well. Maybe it's not your native language. It could be all kinds of reasons, but you can even record these meetings. You just have to notify them that you are doing so. That is very important. You have to notify them. Um, Otherwise, you're violating other Florida state laws. Um, you can share your ideas about what can be done to help your child. What have you done in the house? Are there any accommodations? And we don't think like this as parents. We're not taught that that's an accommodation or that's a modification. But are you doing things that you've noticed help? Like, are you using a picture schedule at home and your child is calmer knowing when the next thing is going to happen? Share that information. Get that in the IEP, because there's no reason they can't be doing that at school. That's an accommodation. If you know that your child can only handle so much at a time and they need to take breaks, that's an accommodation that can be written into an IEP. If you know that the bright lights hurt their eyes, you can ask for an accommodation for that. Is there a darker place in the classroom? Maybe having a paper, like one of those film overlays that like kind of refracts that light against the white paper instead of it just bouncing back into your eyes and really sensorily bothering you. And that could be for a sensory reason or a vision issue. I've definitely known people that had issues with both. So, as parents, we are actually trying all kinds of behavioral things and we are coming up with accommodations out the wazoo, even though we're not trained to think of it like that. You are doing that, and you need to bring that experience and that anecdotal evidence. That evidence that we see through observation or we've learned through doing, we need to bring that to the meeting. We see our child in a lot of different environments, and we are the one coordinating all their care and needs beyond all these environments. So we are critical for painting the complete picture of our child. Know that if you need a translator or you need the documents in your language, that is a absolutely acceptable thing to request. In fact, it's guaranteed to you under the I.D.E.A. And again, plain common language. If you don't understand something, if they're using acronyms, like they're throwing around FAPE or LRE, and you don't know what they're saying, you bring that meeting to a grinding halt and ask what that is and what that means so that you are actively a part of that meeting. You have the right to give, not give, or withdraw consent at any time. They have to have your written permission before they conduct that initial evaluation or provide those initial ESE services. Um, you have several choices. When the school asks for your consent, you can agree and sign the form. You can ask for more information. You can ask the school to change what they're planning. You can just flat out not give consent. So, some things that the school can do without your consent. They can hold an eligibility staffing or an IEP team meeting. That's if you did not respond to the invitation form. So only you can waive your parental participation by not responding to the form and not showing up. Don't do it. If there's any way that you can not do that, whether it's having it virtually, doing it during your lunch break, whether it's, demanding that the time, or not demanding, but requesting that the time and the date be changed. Sometimes it might lead to demanding, but never waive your right if you want to participate. And I hope that you do, since you've stuck with us this far. Um, so, and they can change your child's placement or services, but again, you have to waive your right to attending those meetings for them to do so. So, don't do that. We would strongly advise you to fully participate and stay abreast of what is happening in your child's educational services. So, steps in solving problems. From time to time, you and the school may disagree on what is fair or needed for your child. And maybe sometimes too, like you have the perfect IEP, but it's not being followed. That's still a problem under I.D.E.A. So, the first step in solving a problem is to make sure that everybody understands the problem, that you're at least on the same page about what the parameters for the problem are. The first step is to ask for that meeting, formally in writing, request that IEP meeting. You can call for an IEP meeting at any time that you have a reason to do so. Has there been an uptick in their behavior? Call an IEP meeting. Have they met their educational goals? Call an IEP meeting. Did they regress so much from the end of the last school year when you wrote those goals that they're no longer SMART goals? They're not realistic and attainable. We have to think about this recouping. Call another IEP meeting. You're reading the IEP and you notice it's just not addressing certain needs that your child has. Call another IEP meeting. This is always the first step. They will have to respond either with a proposed meeting date and time, or they will have to give you the prior written notice of why they don't feel it is necessary to call a new IEP meeting. Once that happens, there are other steps we can take. But the first step is always to just have a meeting, try to talk it out, try to see if there's a miscommunication, if there was just an accidental misstep, always try there first. Contact the people that work with your child's teacher first, then the principal, then members of your child's IEP team, that ESC staffing specialist. When I would send notices about my daughter, I would email them and I would attach the principal, the staffing specialist, and the teacher. That way, everybody's just getting all the same information in real time in writing, and everybody is a part of the loop. It's important to understand who to talk to as well. Sometimes parents run into a problem and they really get stuck dealing with school administrators or with a certain teacher or whoever. That is why we have procedural safeguards, is that there is an oversight system. So don't be afraid if you feel like you're just kind of been, beating your head against a wall. Um, know that there is dispute resolution. So that's our next topic. If you and the school district are still, for whatever reason, not able to agree about what is needed for your child, you can request a mediation, file a state complaint, or request a due process hearing. So they all have the same purpose, to solve problems. They're designed to make sure that children with disabilities receive their free and appropriate public education. They are not designed to be punitive to the school. However, in the case of procedural of state complaint, they will have a corrective action plan that will have to be implemented in within the next year. Because again, there is oversight built into the I.D.E.A. So, one way to solve problems is mediation. During the mediation session, a trained and impartial mediator from the state, not from your local school district, will come and they will attend that meeting with you. It'll still be you and the members of your IEP team, because it's important to keep that team, the people that work with your child and know your child and will be implementing whatever comes up as a result of this meeting. It's important to keep it within the original group of people. However, you have this impartial, unbiased person now who is there to, mediate. If you had a legitimate point that wasn't heard, it's gonna get heard now. If, you know, there, if there was oversight, it's gonna be seen and corrected. It's a wonderful way to, it's a least to most approach with these procedural safeguards. Mediation keeps it close. I think it allows for the most opportunity for everybody to be able to work amicably afterwards, the family and the school and the child. So it's a wonderful option for families. For the mediation to occur, both you and the school district will have to agree to it. And then after that, you will be assigned a mediator from the Florida Department of Education. The sessions usually last from 3 to 6 hours. So were you told that your IEP is running too long and they don't have time to address all your concerns? Well, mediations are long. So they will have to find a lot of time to really thoroughly explore and brainstorm whatever the issues at hand are. So what happens during a mediation session is confidential. In fact, it's not for one side to win. It's for both sides to come to a reasonable agreement and to make sure that the meeting and all of the considerations were held in fidelity with I.D.E.A. and its tenets. So, you know, It's a very confidential process. In fact, if you do mediation and then later decide to go do due process, you will not be able to use what was discussed in mediation towards your due process claim. It is a very, very confidential environment. So you can request a mediation at any time, even if you have filed a state complaint or requested a due process hearing. So, you know, the mediation session will give you and the school district a chance to really talk about the problem, explain your points of view, and come to an agreement that is within the spirit and the procedures of the I.D.E.A. and that is in the best interest of your child. So, mediation services are free. If you have an issue that's been going on and on and on, you can have resolution within 60 days. So, this is something that is available to all of us parents. Disagreements are typically solved more quickly through mediation than through the more formal state complaint and due process. And it, like I said before, it really can help you to keep a working relationship with the people in your school, the people that work with your kiddo. So you also have the right to a formal state complaint. So parents can also try to solve problems by filing a formal state complaint. That's going to go to the Bureau of Exceptional Student Education and Student Services, which is BEES. Problems like bullying, discrimination, and behavior of staff do not count as violation of the I.D.E.A. That would be through a separate department within the Florida Department of Education, although there are places that you can file those complaints. And we can actually help you with that, direct you with some of that as well to the people that you would need to contact about those types of issues. Um, you are encouraged to call the Florida Department of Education. The number is 850-245-0474, 0475 before you file that complaint. They can try to solve your problems other ways before doing that. However, if you decide to go ahead and file that formal complaint, you have to describe the school district's violation of the whatever tenet of I.D.E.A. that you feel was violated or their FAPE. You have to explain the facts of the situation as you understand them, and you have to make sure that this only occurred within the last year. So it does have that year timeline. So if you're thinking about doing it, you know, don't wait more than 12 months. During the complaint process, the Department of Education will ask you to explain your complaint over the phone or in writing. The Florida Department of Education will investigate to see if the school has violated a law or a rule under the I.D.E.A. And someone from the Florida Department of Education may visit the school if needed. Within 60 days, once again, 60 days. So if you've been like just grinding your wheels and it's been going on and on and 60 days, again, no cost to parents to file the state complaint. Within 60 days, you will receive your written decision by the Florida Department of Education. The decision will list the findings and the facts of the case, things that the Florida Department of Education found to be true, the list of laws and rules that were not followed, the decision of the Florida Department of Education, and state what the district has to do to correct the problem. So that's that corrective action plan that will be implemented by the Florida Department of Education on that school district. Due process. The right to due process hearing is given to parents and school districts as a way of helping them to resolve disagreements, again, that can relate to the child's evaluation, eligibility, placement, or any of the services within the IEP. This is run by it's a semi-legal, semi-judicial process. We have an administrative law judge that runs the due process hearings, and they work with the Division of Administrative Hearings here in the state of Florida. So the administrative judge cannot know the student or be a friend or friendly relation. They are to be impartial. They are there to listen to you and explain, your explanations of what happened, what went wrong, if you weren't heard, of whatever the violation was. Look at the school district's records, look at your records, look at any applicable records again. So like if you're requesting a particular service and they're saying no, but you do get that private service and it must be valid enough if they're going through insurance and billing with a plan of care, you can submit that as well. It's a chance to listen to people from the school district explain their point of view and make sure that there wasn't any miscommunications or misunderstandings. Listen to the people that you choose to help explain your point of view and to ask questions. So all of that will happen. After the hearing, the judge will make his or her decision based on the rules and the laws. And of course, they're going to be looking at the Florida statutes and the I.D.E.A, which is, of course, the supreme special education law of the land. The due process hearing is a formal procedure. So as in court, there will be some things that apply. You have the right to have a lawyer or to have another person help you. The school district will have a lawyer. You and the school district can have witnesses to help explain things to the administrative law judge, and you and the school district will get to show evidence to that administrative judge to collaborate whatever both of your sides. So if it takes up to 45 days or longer from the time you ask for your hearing to actually get the hearing, and during this time, your child will be protected by stay put placement. So if they are proposing to change your child's placement or change their services, and you're like, wait, no, 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 and you file due process, while you are in due process, so can be up to a 45-day process, right? Your child's services are locked in as they currently are. They are to stay put. So they cannot change the placement. They can't revoke the services. They can't take away the one-on-one aid, whatever it is that prompted you to file this due process. We have to just put a freeze on that, and that will be determined by this judiciary officer. So while you're waiting for the hearing, you will also be asked to try to work things out in what's called a resolution session. If you and the school agree, you can also try mediation instead. You don't have to do that, but it's always a good idea to try that prior to the due process, because then you're looking at the expense of an attorney, because the school will almost definitely have an attorney. However, I will say this, as a parent who wanted to learn all of this stuff and to be able to protect my girls, if you know you're right, the law is the law, and you don't have to necessarily be a lawyer to get up there in a due process hearing and say, hey, this is a clear violation, guys. So I don't want that to be a discouraging factor, but with the mediation, and the resolution sessions, it's at no cost to you. And you can still go through with the due process if those don't result in what you wanted. So just food for thought for that one. The independent educational evaluation. So we get a lot of questions about this. You had an evaluation done, the school had an evaluation done, you're requesting an evaluation, and it's just wrong. It's totally not what you think it should be. Maybe it's not matching what private therapists' evaluations have said. And you want to get an independent educational evaluation. So you can at any time pay to have your child privately tested and bring the results to an eligibility staffing or IEP meeting. They have to consider the information you provided, but they don't necessarily have to choose to act on the information for a variety of reasons. If the school has already done an individual evaluation of your child and you disagree with the results, this is the time that you request the school district to pay for an IEE. You don't go out and get it and hope they're going to reimburse you, because they're not. You put it in writing that you are formally requesting an IEE. And that means that it will be paid at public expense, but it will be conducted by someone who is not a part of the school district, but an otherwise qualified professional to do whatever the evaluation is for. You can ask for that IEE if you have good reason to believe that it was not correct, not complete, or not fair, the evaluation that was done by the school. Basically, think of it as asking for a second opinion. Before asking for an IEE, make sure you have really thoroughly studied the school's evaluation, be able to explain why you think that that is an incorrect evaluation, have some sort of proof establishing that, because it can't just be your hunch. I know he can do that. I feel like he can, we've got to work with facts. We've got to be able to support our suppositions here. So ask, and then you're going to ask the school to do another evaluation or to add to the evaluation that's already been done. And then you can also talk to the ESC administrator in your local school district office or your staffing specialist and say, hey, this evaluation was not correct. It's not an accurate, whatever, if you decide to go ahead and request to have the district pay for an IEE, you should do two things. Call your district ESC office, let them know about the decision, and ask for it in writing. Some school districts actually have a specific form you can use. An IEE can cost a lot of money. Make sure you know that the school district is paying for it before you get it done, because there is not a reimbursement scenario. If you and the school district cannot agree on who's going to pay for this independent educational evaluation, think mediation, due process, right? There's always another step for us parents to go. If we're not being heard, if we feel like this is just really not the correct action, or our kids not getting what they deserve and need, keep pursuing the path. So the school district will pay for the IE if the district agrees to do so, or if an administrative law judge orders them to do so through due process. They will let you know if they are refusing to pay for the IE. Again, this will be a prior written notice. They're going to tell you why they're refusing, what factors they used, everything that was a consideration. And so that's when you're going to start to think about, do I need to file due process about this independent of educational evaluation? The person that you choose to get your IEE has to be fully trained and qualified. That is a requirement for the district to pay for them. Sometimes they can even give you a list of people, but you are free to find a professional of your own choosing to have it done. If you have that and you introduce that, just know that it's going to become part of your child's school records. Discipline of children with disabilities. So, parents and teachers know that it's important for schools to be safe and orderly. So sometimes we know that, certain behaviors and especially violent ones can result in suspension or expulsion. Children with disabilities have the right to receive ESE services even if they have been removed from their placement for disciplinary reasons. We have to look at certain factors with a child with a disability when we're thinking about removing them from their current placement for disciplinary reasons. And they have to be able to continue to receive their services. We have to think about how long they're being removed from school, whether the child's misbehavior is a manifestation, and that's an important word, of the child's, or manifestation, which just means result. Okay, but that word's important. We're going to get back to that. A manifestation of the child's disability. Whether the misbehavior involved weapons or illegal substances, Unfortunately, if it did, this kind of goes beyond the I.D.E.A protections. And whether removal is considered a change in placement, right? Because what decides placement for a student with disabilities? Let's go back to our IEP sections. The IEP, the preceding sections of the IEP is what decides placement, not a student's behavior, unless it was violent, would have caused serious bodily injury to the child, the teacher, or others, involved drugs or weapons. So, a child with a disability still has the right to a least restrictive environment. So, thinking about that in terms of discipline and placement, if you have a child that is getting put in school suspension, is their IEP able to be followed there? If it's not, that's a violation of that child's right. If the child is being put in the office, is there a special educator? Are they getting their related services? Are there accommodations being met there? And are there other children there, or is that the most restrictive environment? There's a lot of factors to think about when we're talking about discipline with students with disabilities. So if you are experiencing an issue with this, please give us a call. If you need more information, we would be happy to give you that information. I want you to know that a child with a disability can be removed from their current placement for disciplinary reasons for up to 10 school days in a school year. So if your child is getting constant in school or out of school suspensions, and it doesn't have to be back to back, it's cumulative. On the 11th one, it's a violation of their I.D.E.A rights. And we need to have what we call a behavioral manifestation determination review meeting. That's why that word manifestation was so important. I said we're going to get back to that. Because is that behavior part of their disability? I've had cases where, students were literally getting in trouble for what would can normally be considered expressions of their disability. But, somebody just didn't want to deal with it. That's unacceptable. So our kids do have protections. If it's the 11th day, we need to do that behavior manifestation meeting. And we need to look at, does this child need a functional behavior assessment and a behavior implementation plan so that we can teach them to better deal with the school environment instead of punishing them like it's not related to their disability. Okay. So, school records. Schools keep all kinds of written records about students with disabilities, personal information, private information, the Family Educational Rights and Privacy Acts, and many others give you rights related to school records, including the right to see your child's records, the right to have them kept confidential, the right to ask for school records to be changed, and the right to have hearings about your child's school records. If you believe that the school district has violated your child's school record laws, you can file a complaint with the Family Policy Compliance Office of the United States Department of Education. And again, if this is an issue for you, please contact us and we'll be happy to get you that information so that you can get that issue resolved. You have the right to see your child's record and to have them kept confidential. So, if you ask, the school has to tell you what records they have on your child and where they're kept. If you ask to see those records, they have to show you those records without unnecessary delay and before any meeting about your child's IEP or due process hearing. The school cannot destroy any portion of their records before you ask to see them, and you may ask for a copy of any records that you see. Sometimes there can be a copying charge, but they cannot deny you access to a copy of any of those records. If you need help understanding any of the content of what is in those records, you have the right to have it explained to you by someone who is qualified to read whatever portion that is. So if it's an evaluation, then you'll need somebody who is qualified to conduct that evaluation to give you the results and so forth. The school records must be kept confidential. They can only be shown to people at the school or school district who have a good reason to see them. They can only be shown to schools or colleges where your child is actively seeking to enroll. Organizations to which your child has applied for financial aid, and organizations doing educational research. You have the right to request that if something is unfair or incorrect, that record be changed. So you have to be able to explain why you think that's a problem with the record. You can ask for it to be, have something taken out and removed from the record, something added to the record, something changed for accuracy. And if you're looking to do this, we highly recommend that you do this in writing via email. And so always create that paper trail and get that timeline started, that you did it in writing on this date. They either will, the school staff will either do what you have asked, and they will send you a letter, a prior written notice saying why they are refusing to make that change and take that action. So they also have to inform you that you have the right to a due process hearing based on this discrepancy in the record if they will not change it. And then you have the right to have a hearing about school records. So make sure that you fully understand what the records say before requesting this. Ask someone at the school or outside the school to go over the records with you. That's something that we could also help with. You can also talk to the school principal about the problem, make sure they understand where you're coming from, what you're trying to communicate. Discuss the problem with your ESE administrator. I like to send emails to both the ESE staffing specialist and the principal and the teacher all at once. It just gets everybody out there. It gets your timeline started. It's official. It's in writing. Hopefully everybody can get on the same page, right? And, write a letter about what you want in this email and ask for a written response. So here is one of our wonderful one-pagers. So every year you are required to receive this awful piece of paper with procedural safeguards. It's a lot of words. Most parents are a little kind of after the end of the IEP meeting. And so I don't know how many of us actually even read this piece of paper. But we have this beautiful, colorful explanation of your procedural safeguards. And this is one of our one-pagers that you can find at fndusa.org. It is very simplified because we want you to be able to take this information and run with it. Here is another good example of a one-pager from fndusa.org. This is the communication ladder. So knowing where to start, don't get mired down in any particular step. If it's been a reasonable amount of time and you haven't heard back, or you're in dispute, keep it trucking, keep it going up the communication ladder. Of course, once you get all the way to the top and you're still not getting heard, you're not getting the response, the IEP is not being implemented, whatever, they're still talking about a change in placement, whatever the issue is, that's when we consider our procedural safeguards. So thank you for sticking with me through the end of this series. It is long, but we aim to demystify this law. This law is here to protect us and our kiddos. And the more as parents that we can dive into it and to understand it and feel comfortable with it, the better advocates that we can be for our kids. So there is no evaluation. A little bit more about F&D. I am in the Panhandle with Poppin, parents offering parents information and networking. We also have the Parent Support Network, the Parent Education Network, and our sister program that covers the whole state, the Family Star, who helps families who have medically and health complex kiddos, as well as mental and emotional health needs. And we are everywhere. We have resources for you no matter where you look. We're on Facebook, Instagram, we're on Blue Sky, TikTok, fndusa.org. Go and snap up those good resources. They are free, they are downloadable. Share them. If you have questions, give us a call. You can reach us at 1-800-825-5736. You can reach us through our website. You can reach out through any of the other means I just listed. And you can actually also take out your camera and connect with me through my little purple bubble here. So thank you so much for your time. It's really important that we understand I.D.E.A. I know it's complex and we have a lot going on, so we don't have time to sit around learning the laws. So it's our goal to make this a little more simple, a little easier, a little bit less scary for you out there. So thank you for sticking with me. This is the end of our It's a Great I.D.E.A. series. And remember, you're never alone. If you have questions, if any of this piqued your interest or made you think, wait, I was told that, or I heard that, or what about this? Give us a call. We're happy to help. Thank you. Bye.